Okay. Good morning, honorable members. Good morning, Oltanda. Are we having a quorum for the meeting?
Good morning, Chair. We don't form a quorum as yet, Chair, but we still have 3 minutes.
All right, just checking that one. Thank you.
Recording in progress.
The time is 10 o'clock now, Chair, and the meeting does form a quorum. Thank you.
Good morning. Good morning, honorable members. Nolthando, may you flag the agenda, please, of the meeting? Yeah, thank you. Thank you very much. Honorable members, that's the agenda for the meeting. Are there additions that members would like to add on this agenda? Well, before that, let me you all welcome honorable members and the DM, the head of department, Ntate Moeli. All of you are welcome to this important meeting where we'll be getting responses from the matters raised during public hearings, both oral and written, from those who came from provinces and all. That will be engaging with and getting responses. We've been waiting for the responses for quite some time. And now is the time to engage with the department now to how are they responding to these questions that were asked by members of the communities, including organizations that have an interest in basic education. And of course, the amendment of this 2B2 of 22, which is a Section 76 bill. You all welcome. We're happy to have you here, DM, but we always not disappointed with you because you always respond positively to our calls when we have meetings. And the DG is always available when we really need him at whatever time. Thank you very much and all welcome to the meeting. You will be getting responses from the department on matters that were raised during what I've just mentioned earlier in the public hearings. Is there anyone who wants to move for? And the minister is in the platform also. Thank you, Memotsecha, the Minister of Basic Education. Welcome to the meeting. Today we'll be hearing the department responding, as I say, that the purpose of the meeting is to exactly do that. And before, without wasting any time, let me take apologies. Do we have apologies? I don't think we do. Nolthando, do we have apologies?
No, Chair, there are no apologies.
Apologies, yeah. Thank you very much. May we give this opportunity to the department to engage, to respond to the issues to the questions that were asked by the public and organizations.
Adoption of the agenda first, Chair.
Oh, wow, okay. Okay, yes, the agenda, honorable members. Is there any mover for adoption? Are there additions on the agenda or is there any mover? If there is none.
I move for the adoption of the agenda, Chair. Thank you.
Yankosi move for adoption. Is there any seconder?
Ndongeni seconds, Chair.
Ndongeni second. I had a voice in the background. I thought there was an objection to the agenda being adopted. Thank you very much. May I give this opportunity to the department to give a presentation responding to the issues that were raised, the matters that were raised during the public hearings?
No, thank you, Chair.
Let's have the minister.
No, it's me, Chair, so I'm not going to take long because indeed the meetings to really get us to respond. I just thought I should really thank you very much for having us, Chair, because we've been on this bill forever. And the more we communicate, I think the better for us. This is the third administration that we've been dealing with this bill. It's almost 7 years.
It's 7 to 8 years.
Yeah, and the issues, Chair, I think when we present them and respond them without being defensive, some of the things we have to do by court, instruction of courts. There would have been cases that the court would have said, amend the following areas. So we had to amend them. So it's not like we woke up and just felt we need to have a good bill. There will have been areas which in the process of consultation, we had to drop, not because I think the reasons were valid, but because the noise was very loud. And I said to officials, instead of delaying the whole bill, let's dump this, let's drop this for the meantime. For instance, the liquor bill, there was so much distortions about it, that the section which was dealing with liquor, because currently the law in our education laws says to bring liquor in the school, you have to get permission from the head of department. And we felt that head of department is far, because now people can bring liquor and then they will say they have applied, so there's no control. We said rather than take that authority very far from schools, bring it to schools so that the SGB and the HODs can be able to regulate the space to say, no, you can't bring. So there were guidelines about when you bring liquor, but we were not able to administer it because of the location of authority. And it just became big noise, and especially because of the season we're in. And I said to them, it's unfortunate that when we withdraw this part, it means the old situation, which was unworkable, is going to prevail. So, and it's been such an unfortunate thing because there have been lots of distortions, lots of misunderstandings. And somewhere, because I said to them, there are bigger things that we have to be able to do with this bill. Leave others, I think the next round of 7 years, we'll see how they deal with them. So that's why I'm very grateful, Chair, that you bring us here so that we can at least be able to get an audience as to what are responses to some of the things, so that in instances where we say, no, we can't change, maybe you understand where we say we can't change. And as I said, we had to change on some very fundamental areas like that, not fundamental liquor. And I said to them, this liquor section is not fundamental to what we want to achieve. Drop it, we'll continue the problems of liquor coming to schools unregulated. And this is what is going to happen. But we really had to quieten the noise for us to be able to proceed. So I don't want to take your time, Chair, the committee, but to express my most sincere gratitude that you bring us, because we really want to speak to as many people as possible, and as far as possible, if we can get this behind us in this administration. The rest of the other remaining matters, I think, are things which will be attended by the next administration, because it will be the fourth. This thing has gone through 3 administrations. 3. So if it doesn't go through now, to be the 4th. And those lingering matters which are critical, like admissions, language policies, will continue with us being able to regulate them. So, Chair, let me not take your time. As I said, I wanted to really express my gratitude and appreciation. DG will really, when we were preparing, I said he should lead into what this bill is all about, because there are also distortions of things which are not in the bill. This is actually more of an administration and management bill. It doesn't talk about curriculum, which is what people have been saying around. It's not talking about curriculum. Curriculum is regulated elsewhere. It doesn't talk about employment. It's regulated elsewhere. But this is more of an administrative and management bill around the running of schools. But Chair, thanks for the opportunity. DG, can you lead the team in the way we have agreed yesterday as to how we want to present to this to the select committee? Thank you very much, Chair.
Thank you, Honorable Minister, Honorable Chair of the Select Committee, Honorable Members, Honorable Deputy Minister, colleagues from both DBE and the Select Committee. As the Minister has correctly pointed out, Chairperson, as we celebrate the 30 years of our democracy, the amendments are informed by the experience of 28 to 30 years of managing the administration of the basic education sector. In the main, looking at bringing about amendments to areas that the Minister said, either instructed by our own experience or instructed by courts in the implementation, particularly of the South African Schools Act. So that experience is actually what informs the amendments that are in here. And we've organized the presentation, indeed, Chairperson, to respond specifically to questions that have been raised in the public. And thank you to the Select Committee for having sent us also a list of those questions. But also to clarify, as the Minister correctly pointed out, some of the issues raised in the representation made by various bodies and entities which were invited by the Select Committee to make representation. But as the Minister correctly pointed out, the real core is about what the bill seeks to address. What is the mischief? And that would be the first part where we depart from. And Mr. Ndlebe is going to take us through those three areas. I want to apologize in advance, Chairperson, because we want to do justice to issues that have been raised. It might take an extraordinary long response because we try to do justice to that. But mindful of time, we'll do our best to make sure that as we respond to all the issues raised, we take into account that the committee has other important matters that it needs to attend to as well. I'm going to request to Mr. Ndlebe to take us through those three areas that I've outlined. Thank you, Honorable Chair. Mr. Ndlebe.
Thank you very much, DG.
Thank you.
Good morning to the Honorable Chairperson, honorable members. Good morning to the Minister and Deputy Minister, colleagues, and the nation watching live these proceedings. I hope the presentation is visible. So the purpose of this presentation will then to provide the intent of the amendments. Some of them, Minister and DG have covered them. And we want to respond to written and oral submissions and provide clarity on matters that were not clear in the proposed amendment. And this is the amendment that we're bringing, which the Honorable Chairperson has indicated in his introduction. And these amendments were brought about by challenges to transformation, which I'm indicating on the slides there. It's about access to education. It's about lack of integration in our schools. There are reports through our monitoring that indicates there are still religious and cultural intolerance in our school. And some of the challenges are those of ineffective SGBs and basically non-compliance to the Constitution in general. We want to remind the committee and the nation in general that South Africa is a global player. It is a signatory to global treaties that promote economic, cultural, and social rights of people. And as a member of the UN and Commonwealth, where those organizations push for the right of the child, South Africa is obliged to meet certain standards to make education compulsory and free. I want to refer you to the African Charter for the Rights and Welfare of Children, which was declared in 1986, which drives the country to develop laws that put the child first. We have statements like "Leave no child behind" as we go along making education compulsory. So the Bella Bill is a response to these treaties. At its core, the bill reflects South Africa's aspiration for a more inclusive, equitable, efficient basic education system. It addresses these key challenges that have for years hindered progress on our education ecosystem. Now, key to this is the implementation of court judgments. We were instructed by the courts, the minister has said in her introduction. So we'll be indicating what the court said and what instruction we were given by the court. We're providing financial and public accountability framework for governing bodies. We're looking at system improvement in terms of learner admission, which is currently not smooth. And we want to make the minister responsible for having regulatory powers that are afforded to her or him from the Constitution in particular, and the oversight role that needs to be played by the head of department in education and the MECs. The rest are just technical changes that are not really making much difference. But we need to indicate as we move on with the presentation, as questions come, that it's not by mistake that the bill is only focusing on administrative processes and governance processes. We do not have issues around early childhood development because that is a section on its own. So the bill will only deal with grade R to 12. Anything below there is covered elsewhere. Minister said, let's not talk human resources because those are covered somewhere where you deal with appointment of teachers and general workers. Infrastructure is one of those things that we are told the bill is incomprehensive because it doesn't cover the building of classrooms, mobile classrooms, pit latrines and sanitation and so on. It is not a mistake that you're not talking about those in the bill because we can't keep repeating laws and put them together. There are legislations around infrastructure. You just go to norms and standard of infrastructure. It will tell you how many toilets are supposed to be there. It will tell you how big the classroom must be, how many children need to be in the classroom, and those spaces are calculated there. So we did not talk about infrastructure in this bill. Inclusive education is something that is covered in White Paper 6. And it is comprehensively done there. If there are changes, they'll have to happen into that document. Curriculum is one of those that is not covered at all because we have curriculum statements which then drive curriculum in particular. So the bill is not inadequate because it doesn't talk about three-stream model and it doesn't talk about online schooling. It doesn't talk about assessment. It doesn't talk about life orientation. Therefore, you're not going to find mention of even sexuality education in the bill because we're focusing on administrative processes. So there won't be any extra curriculum things. And anything that make people want to reject the bill because of challenges with government, the bill is not representing the entire government, where it then gets rejected because there is load shedding and because there are potholes somewhere else. Those are not things that the bill will cover. So those are the limitations that as you ask us questions, you are asking questions based on the clauses that are on the bill. And the bill is not seeking to change the entire system. There are comments that are coming in when people are not happy with the primary SASSA, they want to use this bill to then rewrite SASSA, and that has not been the intention to do that. So the bill is just responding to those issues. As South Africans, we normally want to play lip service to issues like we are a rainbow nation and we are a constitutional democracy. The Constitution is the supreme law of the country, and the Constitution will start indicating basic rights to education. And it will start saying every child have the right to be educated in a language of his choice in public schools, and emphasize this free and compulsory education, freedom of choice and all that. We're seeing lip services to those, but the bill is trying to put effect to those things that I'm mentioning, that if we are a constitutional democracy, therefore, the bill is trying to ensure that those things that the Constitution instructs us to do are then put into effect under the leadership of the Department of Education. Now, we were given instructions of what to respond to, which came from the public, and there were direct questions. So these are two different presentations, and we'll go quickly through on those things. One was section 1, or clause number 1, that deals with definition. There was a suggestion that the definition of corporal punishment is insufficient, and the commentator there gave a definition that looks acceptable to us, and all we said as a department is that we accept the new changes in the definition to include also emotional challenges that are brought into the definition. So we are accepting that definition of corporal punishment. Then we had challenges around the definition of a competent assessor, and it is defined as an educator registered with the South African Council for Educators, and it is said it could be a person that is accredited by the qualification authority as defined by the law. Now, the questions that come in, it looks like we are saying a competent assessor is somebody who has been trained to teach CAPS. There's no training for CAPS anywhere in the country. Teachers are trained as teachers, and the definition is not referring to people who are trained to do that. Only saying the definition wants somebody who is licensed to do that assessment. And that's a qualified teacher. That is a person that the quality assurance has given a certificate that they can do that. And it says there are various curriculum in there: Waldorf, classical, Montessori, and Arabic qualifications, and all those type of things, which we're saying anyone who been certificated to be an assessor in any of those qualifications will then qualify as a competent assessor. There's no restriction of what qualification is. And there's a statement that says organizations that are organizing home education need to be accredited to do that. We're not, as a department, in that space of licensing people. These are done independently, either by SACE or by SACOA. So those assessors need to get certificates from those organizations. And for us, the definition of assessor remains, as long as a person is qualified and has been given a certificate by those authorities, we are fine with it. And it says, when you say parent, the department defines parents as caregivers, as grandparents, and all that. So there's no need to even add those examples in the definition. Remember, this is an act, and an act cannot be a Bible. It becomes concise, and you'll either get guidelines or other things in order to do that. There's a comment, Chairperson, that requests us to go deep into special education. In my introduction, I indicated we're not dealing with special education because it's covered somewhere. So there's no need to even go to town around special education. I know later there was even a question that why put this separate? And the answer is simple, so that it can get more focus where it is than when we put it in here. So those are the definitions that were there. Then there was a request that in the definitions, we must put in micro schools. And we're saying as a department, in the body of the amendments, there's no mention of micro schools. So you can't define it there when it is not in the body. You only define things on section 1 if you're going to mention them in the body. So in the absence of any micro schools inside the body, then the definition cannot be put in there. We'll respond later, Chairperson, about micro schools because there are specific questions that have been asked before. The next comments that we are asked to look at, it's about grade R and the age requirement of grade R. Chairperson, we did not change section 5 of SASSA. Section 5 prescribes the age requirement of a grade R as a child who's 4 turning 5 in June. It still remains like that, so it doesn't change. But it will then deal with the changes around the compulsory school going age, which will have to move from 7 to 6. And the definition of school going age and the compulsory school going age are going to be streamlined as SASSA is combined with the amendments. Then there will be that flow, and it will be that. The opposition that we receive or still are receiving today around grade R, besides the fact that the amendments allow any child, even at a younger age, to be admitted at school if there is evidence that the child is matured enough to do that. And the amendment also allows a child who is not yet matured, even after reaching an age, to can start later, because that child will not have reached a compulsory school going age, so that there can be delays in there. There were also issues of children with special needs who we need to consider. And we know as a department that children with special educational needs are not put in schools according to ages. And age is not a matter in terms of those children. But the biggest challenge is coming in here, where as a department, we have indicated that we will need about 12 billion to run grade R. So in the eyes of the public, it's like we're starting with grade R from nothing. May I remind the public that grade R is being run in this country as we speak. There are schools that have grade R classes. There are community centers where grade R is. There are ECD centers where grade R is. So when grade R becomes compulsory, it's not going to be a shock in the system because it's currently there. There are teachers that are teaching grade R. Others are qualified, others are not. But let's clarify this, that as a department, we know how many schools are offering grade Rs. We know how many schools have grade R classes. We know how many primary schools don't have. And we know how many teachers we have in the sector who are teaching grade R. And we also know how many we will need. And that's where the 12 billion comes from. Then that it can be right for people to say, because you don't have 12 billion, you can't run grade R, and therefore the bill must be rejected. How is education funded? Education is funded by Treasury, and it is funded through processes of government. And grade R now can't be fully funded because it is not compulsory and it is not in our laws. The first thing that we need to do is to put up a law, and the law says start with grade R. And then the funders of education, which is Treasury and the Minister of Finance, will then have to fund it because education is funded through programs. Now, this program doesn't exist yet. And the reason why we're putting it in here is that we want to save the parents who are running grade R from their pockets, and that grade R children also benefit from nutrition, from getting LTSM, and be part of the process. And that the teachers who teach grade R are also included in the post-establishment, because at the moment they are not. And where will the money come from? As soon as you put up a law, Treasury will find money. And that is the responsibility of Treasury to fund it. So to say we don't have money, we can't do it, then becomes incorrect. There's something on learner attendance which talks to 24 hours, and the commentator says the 24 hours sometimes fall over the weekend. We agree that can be amended quickly. Chairperson, where we're going to camp now and really relax, the others we can run through. It's when we talk about the powers of the SGBs that we are told we are taking them away. We are becoming a dictatorship. We're taking decisions unilaterally. It has to do with the language policy and the admission policy. These two clauses, which is 4 and 5, are a cut and paste of each other. Just change the word language and admission, but everything remains the same. In the public hearings, the public is saying these requirements that we put in, that an SGB must within a certain period of time, 30 days, develop a language policy and submit it to the head of department, is undoable, it's cumbersome, and it's impractical. And it goes on to say the HOD has 60 days to respond and approve a language policy, and they're saying it's also not doable. We want to agree, Chairperson, and take heed from that comment and then remove the need for a language policy and an admission policy to be submitted to the HOD so that the HOD respond within a particular period of time. We're taking that with having the following in mind. SGBs do develop policies. It's their job. They have finance policies in their school, they have religious policies, they have safety policies and all that. But none of those policies are submitted to the department for approval. But that doesn't mean the department does not interact with it. Those who monitor schools, the circuit managers, as they visit schools, they do interact with these policies, they do interact with schools around them. So the language and admission policy will follow that line of responsibility. They'll be left in the school, they'll be checked there as and when we monitor them. We're avoiding the risk of rushing through policies that we'll just sign even when we did not really apply our mind in checking them. So we are agreeing the need to submit, the number of days allocated there. We suggest that the Select Committee consider removing those. But what will not go away is the authority of the HOD as the final authority on the language and admission policy and any other policy that is determined by the school. I don't want to speak much about that because it is in SASSA Section 5. When you go through Section 5, it tells you admission is the responsibility of the education department. The placement of learners is the responsibility of the education department. It goes on to say whenever there are challenges about learner placement, nobody goes to the HOD and say, why was my child not admitted? It is a role that is given to somebody that is appointed as a head of department. That is his job description. So that is SASSA, and we're not rewriting SASSA here. So SASSA remains as SASSA. But we indicated some of these things happen because courts have instructed us somehow. I wanted to take you to the South Gauteng High Court, where in one of the judgments in paragraph 72 says the Constitution does not permit the interest of a few learners to override the right of all other learners in the area to receive basic education. They continue in paragraph 73 and say, leaving schools to determine the admission policy, including the power to determine their capacity and subject, only to appeal to individual cases unwittingly, create space privileged schools can use to manipulate the power. It goes on to say, to fortify, it says schools can be used to manipulate the power to fortify rather than to dismantle existing inequalities. Paragraph 75 says the question arises, what would happen if a large number of schools grouped together decide to alter the admission policies to reduce the number of learners they would accommodate? Then the judge says the MEC will simply have to accept such attempts to derail the movement towards substantive equality and in the process deny children their rights to basic education. It's not the Department of Education that says that, it is the courts that says that. All the judgments that have happened, MLO judgment which are being quoted here, the judgment in the Free State, the overfile judgment as well, that has been considered. This culminated in a constitutional judgment. Now we're talking the Constitution now, which everybody understand what that court stands for. And the Constitution has to say around judgment, especially in Gauteng, that's why the SGB determines admission policy. Individual decisions on admissions are taken only provisionally at school level by the principal acting under the authority of the HOD. Where the need arises, the judge quotes section 5(9), provides a safety valve which allows the MEC to consider admission and refusal and overturn an admission decision that was taken at school level. And then they go on to quote the MLO and the Velcom judgment that dealt with pregnancy in them. They continue on paragraph 54 and say, however, having found that the Gauteng HOD was lawfully empowered to admit learners to Rivonia Primary School, the suggestion that the accounting HOD was rigidly bound by school's admission policy when exercising that power is untenable. That a policy serves as a guide to decision-making and cannot be binding, cannot bind the decision of the maker in inflexible. That judgment goes on to quote the Akani Pinnacle versus Pinnacle and the MEC of Agriculture and so on. But what is key is that there are laws, regulations, and rules that are legislative instruments where policy determination are not laws. Policy determination cannot override or amend or be in conflict with the laws, which actually means the power of the SGBs are not obsolete. Education department exercise ultimate control power over the department to be exercised reasonably. What the courts went on to emphasize is that the department and school governing bodies must find one another. The HOD cannot just come and impose himself when things are not in line with legislation. And that is what the bill is trying to do in section 4 and 5, give steps that the HOD must follow when he engages with an SGB that has a policy that is not aligned to other legislations and the Constitution. And that is the basis of this section 4 and 5 that says it's not wrong where we're saying the HOD is the final authority, but the HOD has to follow certain steps in order to make it legal. And the SGBs cannot determine their own policies, and it ends up there and they become a final word. And the court says, stop running to us every time, find each other. And we have put steps as far as that is concerned. I want to move from 4 and 5 and talk about the code of conduct of learners. And there was an indication of a definition of just cause, which the lawyers in the department says there's no problem with just cause. You can leave it as it is. And there's a statement that we need to indicate that children can be allowed to be exempted on religious, cultural, and medical grounds. We want those statements to be included as suggested. That these are the reasons that a learner can be exempted from participating in a particular activity in a school on religious, cultural, and medical ground. We are accepting that, and we'll request that it gets amended as well. These ones, it's about misconduct. No argument. We support what has been said, that has been recommended to us. We don't have a problem with that. The search and seizure, not a serious issue where it says, should the principal keep illegal items that are confiscated from the children, or should be transported to the police station? We're saying that the code of conduct and the school policies will determine how to deal with this, but there's no issue of major difference whether the principal send it to the police station or not. This section talks about central procurement. We acknowledge as a department that we have been warned by the High Court in the Eastern Cape that the way central procurement was conducted in that province is incorrect. And the commentators are saying, you buy us materials that are cheap quality. You're buying us things and you deliver them late. You're not even consulting us on those decisions that you're taking. And we're saying Section 21 of allocating funds to schools has not changed. So Section 21 still remains in control of that process of procurement of goods and services. But what comes in clear in the bill is the word in consultation, which was not there when the judgment in the Eastern Cape was taken. So we're saying we're putting steps now that if there's a need for central procurement, that central procurement follows these processes. And instead of a van or a truck delivering material and the school doesn't know where it comes from, need not happen. It must happen in a particular fashion. DG will go to town and explain the advantages of central procurement for the economics of scales. But the aim is to get as much resources as possible so that we can meet what we call every learner having a textbook in his hand. And we can do that if all schools or schools in an area put their funds together, negotiate prices for the sake of economics of scales and get cheaper. DBE has done that successfully. We deliver workbooks to every school in the country, and we get that very cheap. We managed to deliver textbooks in Limpopo when there were problems because we were able to negotiate it so that we can get what we call universal coverage of textbooks. Now, key consult. If the department does consult and find goods cheaper, same quality, same title, same everything cheaper, and then they'll have to consult a school to say, it's cheaper here, let's all go and buy from there. But if a school believes that they can get it even cheaper elsewhere, that's where the process of consultation comes in and say, yes, go and buy it where it's cheaper. It's about getting it cheaper so that you can get more. It's about saving money so that the money can be utilized elsewhere. And it's about that consultation that is in there. So we want to indicate that with central procurement, the key word is that the department must never do these things alone. And when you go through the bill, you'll get a clause that says what happens when the SGB and the HOD are at loggerhead. It is a braking mechanism that is going to be found in the bill itself. And that's our response when it comes to that central procurement. So this one is about dissolving SGBs and said those that will come in as interim are given too much powers. I mean, they're not coming in as dummies if the SGB has been dissolved. They have to carry those responsibilities and the powers allocated to SGBs within that period of time when they are still in there. Just a short comment here that says the chairperson of a finance committee must always be a parent at all times. And the question here is that why are we putting it as if schools have a choice? Why don't we say it's compulsory? And our response is that this South Africa is has unequal societies. There are communities out there where the parents may be in the SGB and those parents may not understand this role and responsibility that we're giving them. It happens in South Africa, but those who live in urban areas may not understand. That is why we said, where practical possible, where it is reasonable, then you can have somebody who's not a parent to do that function. And these are few cases that may be, so we don't want to close them out. So we want to leave that sentence as it is, as reasonable, practical, because there are places where nobody goes to, where nobody drives to, no car goes in there, and only to find that the parents may not be able to do this job that we're talking about. The next one is that let's not rewrite SASSA. Section 12 of SASSA talks about merger and closure of schools. But what was missing is the accountability of the department when they merge and close schools. That sometimes we become excited, we merge schools and close schools that we're not supposed to. We merge schools when we're not offering any alternative like transport and all that. So that section has been amended to ensure that departments are going to follow the rule of law and they're going to follow all steps as prescribed. So we're putting more steps, not challenging it in such a way that one will start debating whether we remove the merger and closure of schools. It's not about that. It's about improving it and show how it is done. There's a suggestion here that loan needs to have a cap. If they have to apply, how much must the cap be? If you're in South Africa, you'll understand our schools are unequal. 500,000 rand is too much in another school, whereas in another school, 5 million is nothing. So how do you cap it when the schools are unequal? It's just like petty cash. A petty cash in a school that I taught you was 100 rands. A petty cash in another school might be something far more than that. So you can't put a cap on that. This was just a request that we remove the head of department and we put the minister to be responsible for giving directions on finances, especially on the funding model. I don't know what the challenge is because the funding model comes from the national office. So we can't have every HOD coming up with a funding model. So we will remain with that clause as is. Deviations? We're saying budgets are passed by parents around September. Schools get a mandate from parents to approve school fees, to approve the budget and all that. But SGBs tend to go back and change this on their own. And we're saying if they want to change the budget, they must not change it. They can only change it if it's less than 10%. Anything beyond 10% needs a fresh mandate. You need to go back to the parents and say, hey, you gave us a mandate to do the following. We're now changing. We want to redirect these funds to something else. And the question is that it's cumbersome, it's waste of time, it derails. And if you look at the Constitution, especially Section 95, consultation and accountability and transparency, you bring those things together, it means you can't deviate on your own in your own office, the 10 of you, when the members of the school have said, we agree to use our money in that fashion. So we're saying, Chairperson, the deviation will remain, that if it's over 10%, it needs a fresh mandate, or else people are going to use public funds the way they want without using it for what it has been intended for. The next one is about financial statements. We're saying as a department, the financial year of a school starts from January to December. And then SASSA gives an allowance and say, you can send your audited financial statement by 30th of June. Calculate that, it's 18 months. Money used today, you can report after 18 months. And we're saying as a department, when that happens in a country that is full of fraud and misappropriation of funds, if anybody has to intervene, it will be too late to intervene. It is important that there is a mechanism to ensure that misappropriation and funds and mismanagement of funds are detected in real time. We would have loved to do it on a monthly basis, but we're saying on a quarterly basis. Now, the argument is that when we do that, we're putting pressure on schools. Let me remind you, we're not talking audited financial statement. We're talking income and expenditure statement. As you spend money, you withdraw money, there's a record that you've withdrawn. As you purchase something, there's a record that you have purchased something. We're asking you to add those things and send. There are statements that says teachers will be overburdened. They'll run away from classroom to do that. I thought most of our schools have admin clerks that are doing these things. They have buzzers that are doing these things. And it doesn't require any much effort and time, because it's a matter of reconciling those incomes and expenditures and the bank statements and report to the department on a quarterly basis. The same thing happens with independent schools that are saying it's cumbersome and all that. It's just about to bring accountability. And another motion that is coming is to say there are schools that get clean audits. There are schools that are run well. There are schools that are producing well. Unfortunately, we cannot have laws that apply to certain schools and other schools do not fall under that law. If we're saying all schools need to provide us with financial statement on a quarterly basis, that is all schools, because it doesn't mean well-run schools are not tempted or find themselves under this misappropriation. And sometimes it is those schools that have millions and millions of rands where sometimes money cannot be explained where it has gone to. So, Chairperson, we still, as a department, requesting that we request schools to do that and provide us with those so that the head of department can intervene, can appoint accountants, can bring in the Auditor General if he smells a rat somewhere. Subsidies of independent schools, the issues that are being raised there are more administrative and all that, but there is that objection of quarterly reports. And with independent schools, it's only 3 times a year because they have got 3 terms, and we want to leave it as it is. This one, it's home education. The complaint is about the power of the HOD. Chairperson, I just want to go straight to the Constitution. And the Constitution allows for independent schools. And home education is one of those. And the Constitution and the department acknowledges that these schools provide parents with added choice with regard to the schooling of their children, and also provide a service that their children will otherwise would have been borne by the state. We recognize that children are not the same. They learn differently. Others don't cope in public. We acknowledge the fact that parents sometimes need to have their ethos and values instilled in their children. Their cultural and belief and religious rights are embedded in that belief, and that children work at different paces, and children are differently talented. Others may be slow. We acknowledge all those, that's why there is home education. There is home education to cover that gap. It's a constitutional right. So it cannot be right to say the department is trying to block, the department is trying to infiltrate. I'm quoting section 29(3) here, that says everyone has the right to establish and maintain at their own expense, Constitution speaking, not the department, on expense, independent education institutions that are registered. So we're not picking the word registration from the air. If we are constitutional democracy and the Constitution says register, who are we then to want to fight that word? And it goes on to say, register with the state and maintain standards that are not inferior to the standard comparable to public educational institutions. Nowhere, Chairperson, is it saying register and teach CAPS. Nowhere is it specifying what curriculum a parent must do. But it says the curriculum of your choice, as long as it's not inferior to the one that government institutions are working. If you go on with SASSA, you will realize that there is an obligation on the head of department to know all the children that are in school, and those that are in independent schools, and those that are homeschooled, and those that are not at school. And that cannot be effected unless there is registration of some sort. There is an argument, Chairperson, that it's our parental right, it's our God-given right to raise our children, and nobody can tell us to register or give us permission to. Chairperson, the Constitution does limit rights. There are limitations of rights. You can't be allowed to home educate your child if you're mentally disturbed. You can't be allowed to educate your child if you are a member of a particular destructive cult. There are parents that are by law not allowed to have children under their care. Hence, children are taken by the state. And some parents are included in sexual registers and all that, and have been deemed unfit to raise children. So every right has a limitation. And even those who want to run home education need to understand that the right is not obsolete. There are conditions under which they must fulfill and satisfy those conditions. We are told, especially by those who are home scholars, that this competent assessor that we talk about will not understand the curriculum that they're doing. And we're saying, who appoints that person? Because the competent assessor is appointed by the parent who belongs to that curriculum, beliefs, and all that type of thing. All you need is that the person must be certified to do that job. And there are questions that the department does not understand home education. You did not even research on home education. We find, because we're not offering home education, you are the parent who wants to homeschool your child. You're the one who needs to research more. All we're interested in is the professional that will come to us at the end of a phase, and we're not even assessing these children on a quarterly basis or on an annual basis. We know they don't use grades, but we say at the end of the phase, somebody out there must say to us, the child is receiving education, and we will accept that. So we're not going to get involved in how you educate your child, in other words, but we will know through the people that you're going to appoint who are certified, and obviously they can't lie unless they lose their licenses. That is homeschooling that I've been dealing with. And I've got this one that says Section 39, it's vague. I want to read Section 39 and what it says so that we can really make a decision here. It extends the power of the minister to make regulations on the management of learner pregnancy. Please count with me. 1. On the admission of learners to public schools. 2. On the prohibition of payment of unauthorized remuneration. That's 3. On minimum norms and standards for Provincial Teacher Development Institute. On district teacher development. On organization, roles and responsibilities of education districts, and National Education Information System. It means there are no regulations on all those things. But all the objections that are coming for Section 39 are referring to pregnancy, which is one. What about the rest? And when it goes to pregnancy, it then brings in curriculum issues of life orientation and sexuality education. And we even go and bring in abortion in there, where we're now confusing the Department of Health and the Department of Education, where termination of pregnancy in the health department, which talks about children of 12 and how it should happen, is now brought in, where all we are asking is that, Minister, there's an empty space here. We don't know how to deal with pregnant girls. And would you please come into the space and close the gap? That's all that it says. But where abortion comes from, where masturbation comes from, and where sexuality education comes from, I don't know. Because that Section 39 is saying, Minister, these regulations are not there. Please put them in place. So people come to the meetings and say, we reject the Bella bill because it's an immoral bill. And you want to throw everything. So we reject the Bella bill on something that is not on the Bella bill. When you look at the next slide, you get now recommendations. Recommendation that says, Minister, do 1, 2, 3. So, President, what is the understanding of development of a regulation? Because it looks like people don't understand. The minister doesn't sit in 222 Struben Street and write a document and send it to the world and say, that's it. When it says the minister develops a regulation, it means the minister is going to find people who are some of the people that are recommended by the ACDP here, that will have their inputs. And it will go through. And the minister can't work outside provinces with MECs. That is why we have CEM. And that's why we have HEDCOM that Mr. Mweli needs to manage with the HODs. And there are officials on the ground. And there will be consultation. There will be gazettes for public for comment. There will be these hearings like this. That's how regulations are made. So if it says the minister must regulate on learner pregnancy, understand what that means. It means the minister must initiate a process of community involvement, and all the specialists and all the health specialists and everybody that's in there, so that you do it. So the bill is rejected on something that is not there, something that has not even started. And all that is required is all the recommendations that you're putting on the left-hand side are all the steps that are required in order to come with a regulation. And that's what the bill is saying. Reimbursement of members of SGB, yes, it is in SASSA, it is in the bill. When you spend money as an SGB member on behalf of the school, you must be paid back your money. Simple as all that. It was a question. Teachers are not state employees. I think it's about teachers not doing business with the state. And it says now remove teachers, leave this with the state employees. And we're saying teachers are state employees. You can't have a teacher running a business to supply stationery paid by government and also running nutrition in a school. Chairperson, those were the comments that we received from the hearing that we received from your office, and that's how we're responding to them. But then you gave us specific questions from different organizations. And that is the organization, and questions are very specific. And what comes to mind here is the last one that says, it looks like the Bella Bill is targeting the Afrikaans language. And we think, let's not make the Bella Bill an Afrikaans issue. There are 12 languages in this country. And there are monolingual schools in every language. The apartheid system has demarcated our areas in that fashion, where there are areas which are predominantly Zulu-speaking areas in Zola, and their schools will be structured in that fashion. But what you need to understand is that the demographics have changed. People have moved into areas, they have bought properties, and they speak certain types of languages. And those languages need to be catered for where they are. And basically, that's the answer that we want to give. And the definition of corporal punishment, I've dealt with it. And where it is said there are no procedures for independent schools to deal with the head of department is not true. On the right-hand side, I'm giving what happens if you're engaging with the head of department. Those are operational matters, challenges that independent schools always get when they work with districts or provinces. Is not a matter of the law. The law is clear. And if districts are not managing this correctly and provinces, there are systems that need to be followed. And one of them, because they're independent schools, is the direct one. Give a call to Mr. Mweli. Mr. Mweli will give me a call, and then we'll intervene. It's as simple as all that sometimes. These questions are questions that are talking about the powers of the SGB, which I've gone on to explain what the powers are from the Constitution. It's questions that are saying, will this pass the constitutional matter? But if it's the Constitution that says the HOD has the authority, then we are confident that the Constitutional Court has spoken. And it is around those powers of the HOD to make language policies and says who has the authority. It is the HOD, and I've given you the Rivonia case and the judgment that it goes on there, which made us to go and change that. And it is SASSA, other sections that says those admissions are the responsibility of the department. And even though you can have democracy and democratic decisions, all those autonomies and the democratic things are still subject to scrutiny to see if they are in line with other legislations or not. And it goes on again to say, well-functioning schools who have clean audit must be allowed to. We're saying all well-funding schools still have to account And this is an accountability system that has been put in there. The question still talks about funding of Grade R, which have gone to town to explain that funding will happen from Treasury. And Treasury has given a note that says, yes, we will fund. And this is how they call it unfunded mandate, and say the department has followed procedures on how to deal with unfunded mandate. So they are waiting for it to be passed before they can do anything. And the word parent for us means everything, guidance and all that. To determine whether home education is of the best interest, that's why we register. And the question here is, what research is DBE relying on deciding whether schooling is the best interest? And it goes on to say we have done very little on researching on home education, which we said, fine, but you are home educating. We have these millions of children that we have to look at, and we're happy that you are taking responsibility for your child. It then goes on to argue around employment opportunities when schools are merged or closed, and we're saying we don't have retrenchment packages. When a school is merged or closed, nobody loses a job. And the person says, isn't it a missed opportunity to implement district development model when you close schools? I said, it's an opportunity for the community to utilize that school for the benefit of their community by repurposing that building. And DDM that get affected in that fashion, where the community will make best use of an unused building using the DDM process. And we are asked, when we do central procurement, we're going to buy books that have sexually explicit themes. It looks like we have a department that is very irresponsible. These textbooks go through a rigorous process, and they will not be bought by the department unless they have gone through that. And this one talks to aspects of special needs, which I said are not covered. And that's where they are. We then asked about qualifications of caregivers. And our response is that that is the responsibility of higher education to determine qualifications after matric. And I think they are open about it. There is what you call Mr. Tech, is a document that talks about qualifications and teacher qualifications in particular. The questions from FESAS, accountability on admission and all that, that's where we spent a lot of time. And the next one says the requirement to submit policies within specific, we agreed with removing it, Mr. Deacon, and we're putting it on record that we would love to remove it if the Select Committee agrees with us. Capacity of schools, it's a court judgment, Minister. You were instructed in October by a court that you must from October come up with regulations around school capacity. You were given 3 years to do that. And what I can report is that I'm the chairperson of that committee that will determine school capacity. I've already have about 4 meetings already. We will follow all the processes, consultation and all. And within a given period of time, we would have agreed regulations on the determination of school capacity. So, Mr. Deacon, you can relax on that. It's in the pipeline. The last meeting that I chaired was yesterday, by the way. Central procurement, we have indicated that consultation process and that there are steps that needs to be followed. If they are not followed, definitely then it means the procurement will not go ahead. And remember the section in this Bella bill that talks about how you deal with dispute with the department. And the question, why are annual reports inadequate? The audited financial statement. I've indicated that, it takes too long. By then, the bank account in some schools is already empty by the time they bring you audited financial statement. It's still the money, how we're going to ensure that the Bella bill is funded. Yes, it's funded by Treasury through equitable shares and through different programs. And we're saying the budget can't be made available unless there's a law that provides for that. And it's cost and cost again, and which you said we have given, and through the sales, and we've got a certificate that we have followed the processes correctly. And if you understand the funding in terms of programs, you will know that there's money for infrastructure, there's money for curriculum, there's money for, so there'll be money for. So we can't say now that we're bringing grade R, then money will be taken away from infrastructure. That's not how government works. We use programs to fund government requirements and laws. These questions from Action SA about the definition of basic education. Basic, I don't know, it just means something before tertiary education, whichever you want to call it. Pre-tertiary, basic, it all comes to the same thing. And the curriculum of grade R, somewhere I've indicated this animal called grade R is not new. We're running grade R now, all over, in our schools, in our centers, in all that. So it's not like we're going to start having to worry about the curriculum. Everything is there. All you need to do is just to make grade R compulsory, that when you have a legal journey is not going to start at 1, will start at I. That's the only difference that is there. The age I've indicated, go to section 5 of the original R is children that are 4 turning 5 by the end of June. Why are oversight mechanism of SGB not developed? So if you read the bill, you're going to find things that say SGBs hold annual general meetings, have financial statement, recuse yourself if you're an SGB member on issues that affects you, be a chairperson when you are a parent of the finance committee, removal of ineffective SGBs. All these steps are meant to strengthen the oversight mechanism. That when you play oversight, there are rules of engagement. There are things that are there. So your question, it's about oversight that you need to play, and this is how we are strengthening it. Are we departing from the Constitution? No. Language issues, there are 12. There can't be in this country the majority of the children that go through schooling system unable to speak their home language because there are only 2 languages that are taught in a school, irrespective of the fact that the school has 80% of learners who are Black, predominantly so, but none of them speaks a home language at all. So we're not differing from the Constitution that says treat these languages equally. Are we not undermining democratic governance principles? No. Take your democratic principles, but align them to the law, then you are fine. You don't have a problem. Hoërskool offerval. The issue of hoërskool offerval was that the department was trying to place learners in a school that was already full. That was the issue. And that judgment emphasized the fact that don't even count specialist rooms like laboratories and libraries as classrooms because they are not. A school that is full is full. That is the basis of the offerval judgment. So we're complying with that. And I think even going forward, even when a school introduces additional language, it doesn't mean the school will be allowed to overcrowd itself. Because there will be the determination of a school capacity. And it's the overfall case that I'm saying again, which I'm still saying, if the school is full, it's full. But the responsibility to have learners place still lies with the HOD. And with the overfall case, what was specific is that there were neighboring schools that were empty. Not empty per se, but that could accommodate these children. Why were they forced into overfall? And that's how the Department of Education in Gauteng lost that case. The questions continue. It's an oversight again, and the final decision. And we've read court cases that are saying that the SGB cannot have a final decision. That's how it is. They are doing their job on behalf of a department, but there are processes where they differ and how those things need to be done. We were asked here, what did we do with the submissions of homeschooling? And to be honest, they were not submitted to us. They were at the Portfolio Committee on Basic Education, and the Portfolio Committee sat with those, went to National Assembly and all that. So everything that is submitted even now is not ours. It belongs to Parliament. So all we know is that they deliberated upon them and they made a decision, and that's the decision that ended up where we are now. And competent assessor, I've gone to town around it. UBE and officials are not trained in home education. Yes, they are not trained in home education. They are not going to run home education. Home education is run by the parents at home. Admission, independent schools, just a repetition of what I've answered. And the problem around Afrikaans as being targeted. And we're saying all schools, Afrikaans, Zulu, Venda schools need to cater to the needs of the children who live in the community they serve. The introduction and treatment of language equally should not be reduced into an Afrikaans debate when there are millions of children who are forced to learn in the medium of Afrikaans and English with complete disregard of their mother tongue, even in schools where they are in majority. We repeat, don't make it an Afrikaans issue. There are children that are Sepedi speaking, but they are taught in Setswana because the language policy of that school is. Even though the number of children will increase in that area. The fact that districts are not supporting school is not a problem of the act or the law. These are operational issues. The last one, the last bullet talks about agricultural schools that are going to die. And we're drawing the attention to the commentator that clause 12 provides for the SGB of a public school to apply to the MEC to be designated as a public school with specialized focus. Schools of agricultural, special schools of motoring and engineering, schools of aviation, and school of marine, and all those. It actually gives you more power as an SGB to redesign your school if it's not serving the purpose. It's about homeschooling. What happened to the submissions by Pestalozzi? the question should be directed to the portfolio committee. And as I said, they engaged, they decided. The issue of curriculum, we have indicated. Are we even looking at international law? Yes, the fact that you're saying a curriculum of your choice, and most of these curriculum of choice that are done at home education are all curricula designed out of this country. So they are international curricula and we are accepting them. So it means we are aligning ourselves with the international convention. That is why you are able to teach your children on the basis of the British curriculum, and nobody says anything about it. So the freedom of curriculum is there. We do not prescribe what and how you must do it. 39, I've gone to town. I don't know how it promotes sexual sin and abortion when it's not saying that. And no regulation in this country is promulgated without public participation. If we're going to come up with regulation on 39, public participation will be involved fully. The closeout of small schools we have added. It's not about money. It's about the fact that there are no children in those schools. You can pump in money, but if there are no children, then it makes it impossible to teach the few that are there. There's a question about consultation, Chairperson, that the minister has never consulted with organizations that deals with homeschooling. The slide on the right-hand side is giving you dates as early as 2014 to 2023. It's telling you who did the minister meet with, what date, and all those organizations that are listed there. Issues like roundtables that have been set and discussing that. Some of us were there because we even shared some of these breakaways in that. And the different task teams that have been established. If that page doesn't indicate consultation, then I'm not sure what consultation is. Lack of research on home education. The Constitution allows for home education. And what are the issues? You want us being trained to come and manage your child at home? No, it's a decision you've taken. You're going to home educate, but you want somebody else to be trained to come and help you when you're home educating. We're not sure. This innovation and access to education and all that, the bill allows for access to education. Let me indicate. Deal with management of absenteeism to reduce dropout, that's access. Keep pregnant girls in schools, that's what the Constitution demands. Criminalize disruptions of schools, it's about access. Call for human treatment of learners in schools so that you remove initiation, you remove corporal punishment. All these things about access and keeping children to school. And that's what the bill is emphasizing. Penalties that are imposed, it was there. So let's not even start talking about removing penalties because it was there. We're just increasing it from 6 to 12. And that's why I was saying lip service to the Constitution, free and compulsory education. But the word compulsory, then we don't understand. When we put compulsory measures to ensure that children are at school, then there's a problem. We are too harsh, but we want this compulsory education. How does it happen if it's not enforced somehow by a law? It's like when you say children in the neighborhood have arrived and they are Xitsonga speakers and they can make 2 classes full, then it means your school is going to go dual medium. It doesn't work like that. And it's like teachers are going to be forced to teach in different languages. No, each language must be taught by a qualified teacher. If you're an Afrikaans teacher and you have to teach English, but you've been trained to teach Afrikaans, then you're not qualified to teach English. And that's how it is. And we don't have laws that deals with SGB's employees because that's what you do. But those that we provide are provided on the basis of their qualifications and the subjects that they teach. So it means it is the responsibility of the department that if there's a language that has been introduced, then there must be resources that goes with that. And that is where the HOD and the SGB must find one another in ensuring that it is done smoothly and correctly so. Because it can't be an imposition. Why will teachers then have more homework to mark? No, the job description of teachers is agreed upon at the Education Labor Relations Council. Workloads of teachers are prescribed in the personnel management measures, and which is found in the Employment of Educators Act. They are not imposed by the department. So a teacher cannot just have a workload that is beyond what the law prescribes. The taking of powers, we have indicated, you have them, you use them, don't abuse them. If you go wrong, there must be an adjudicator, and the adjudicator knows what to do. The problem with this here is that when we say the community, we're not talking about the community per se. We're talking about the few parents that have children in a school, because those who are not at school but living in that community hardly get addressed and attended to when these decisions are taken. But the bill says we will go to town around it. And we don't know how we're talking about subsidizing salaries of SGBs because we don't deal with the payment of SGBs. And how the building of schools that doesn't. If a school is full, it's full. And if there are not enough classrooms, there are not enough classrooms, then you cannot accommodate it. Overfund is that example. There's a court judgment that if it's full, it's full. It's still language. Home language is what we want to deal with. We want to promote this home language, because there are those number of languages. Decentralization of power, we agree, but there's a rule of law and adherence to those legislation, that those policies cannot override legislation and the Constitution. Provincial departments are not funding and resourcing schools as per current legal framework. So it's not the weakness of the law here, it's an operational challenge that we're dealing with. Central procurement, we've gone to town around it. And we're saying Section 37 of this bill sets dispute resolution mechanism between schools and the department. We're talking here age of admission and compulsory school going age, we should try to deal with. And indicated what a school going age is and what a compulsory one does indicate. And it says, how do we ensure that sexual misconduct linked clauses incorporated? We can't put sexual misconduct in the Bella Bill because it is in the Employment of Educators Act. Section 17 and 18 of the Employment of Educators Act will deal with issues of teacher misconduct. So we can't put it in the bill, it's there. Criminalization is an issue. Where we say anyone who prevents a learner from accessing education, it doesn't matter who, it says anyone, to give effect to what we say compulsory education. So we'll criminalize anyone, whether it's a teacher blocking children from attending school, and anyone, exactly means anyone. And it says here resources must be given to the poorest first. I think government is poor in all its work, and it will continue to do that. When you want to talk about the poor and all that, it's now norms and standard for funding. It's another law. So we didn't repeat it here. The capacity of schools, I said we're working on that. Decisions of the SGB, it has been the story of the day. Yeah, the answers are there. I hope Honorable Chairperson, members have gone through these responses in advance. Because if you ask me, how will a guardian know what's happening in a school? It's like, obviously there are newsletters. The child that you are looking after will have to bring information to you, like any other parent. And teachers who are not under SACE, we don't discipline only children, teachers who are under SACE. Disciplinary process will cover every teacher, but it's the misconduct not to be registered with SACE in the first place. But the laws will apply to everybody. And if you think corporal punishment definitions need further refinement and the offenses and the responsible of justice, yes, there need to be regulations or guidelines to handle that. And here's the questions that come from the school, where we don't see a link between admission and equality, unless if we're saying when we select our own learners, the quality is guaranteed. And the bill is trying to say to you, don't select your own learners according to your criteria, which will be discriminatory. If that's what it means, that the quality of education will drop, then unfortunately, we'll have to apply the law that don't discriminate. Because I know of grade 8 learners that are selected on the basis of their reports in grade 7. And others are even given tests. And you're told, no, you couldn't be admitted here. But they won't tell you that it's because of your results. Other reasons will come in. And that's when we need the HOD to intervene. And this school says they have carefully crafted language instruction framework. And we agree with them. If they are carefully and well crafted and are aligned with the Constitution, then you have no problem to worry about. Continue using them. Maximum capacity. We don't encourage overcrowding. I want to quote the minister somewhere where she says, "What you don't overcrowd your cars. What do you want to overcrowd my schools?" Overcrowding can happen if it's the only school in that vicinity and there's no other school, there's no transport, there's nothing. Because a child in that overcrowded classroom is better than a child that is in the street or at home. But under normal circumstances, we do have our schools that are deliberately overcrowded for other reasons. And that cannot be allowed. Budgetary requirements, we've gone through it. I don't know what Northcliffe means when it says they are imposed with children who do not meet the criteria. It's a high school. Does it mean the child did not pass the previous grade? Or what criteria? Is it the zoning? Is it one of the criteria that probably may be illegal? I don't know. But Section 37, again, allows you to have a dispute with the department that can go up, and get resolved somewhere. And Northcliffe wants to know about Section 21 schools. And I'm saying it's not taken away. And in consultation with your SGB, that's what will happen to get concurrence if at all you're going to buy materials. The questions are continuing. Whether we appeal to the MEC and the courts, it doesn't stop anyone from doing that. But the court says, find yourself first if there is an abuse of power. Similarly, SGBs do abuse their power as well. we don't know what this means, that state must fund learners or schools via tax-funded vouchers. Well, we're just saying it's an option we never thought of, we never discuss it. If it's a viable option, we'll be interested in knowing the details so that we can engage around it. Yeah, it's like the fathers here have an issue with pregnant girls being at school. And we're saying as a department, we're not given an option here. The Constitution says they must be in the classroom, and that's what we're doing. And then there are statements like we are hiding rape of school girls. I don't know how we do it. And the department is refusing to meet them. I don't know. They've been requesting to meet with us. Here we are, ministers here, DM is here, DG is here, DDGs are here. We're all here as a department, and we're saying from today, give us a call and see if that meeting wants it. There's a request that we put up a provision obliging government to form intergovernmental committees. These exist. GG will be with FOSAD, there'll be committees of the social cluster and all that, at all levels of government. Whether you want to talk about the Department of Home Affairs with us, we've got these levels. So we do not need to create any. They're there and they exist. The authors here are saying the documents that we require for admission are too many and cumbersome, and we just need to deal with the birth certificate. The answer is no, we need all of them because they help us in running education better. But the authors understand that we do not reject children from admission if they don't have documents. So let's differentiate the two. The documents are required. We need to make sure we get them. But no child will be refused admissions because these documents are not available yet. So let's differentiate between the two. And the process followed, if the SGB is not satisfied, it's covered in the bill itself. And we can't have sections that deals with reviewing of policies because all departments have policy and planning units, even at district level, and there are legal services, so we're not going to duplicate on that. Just cause, we have explained it. The training of SGBs, it is in section 19 of SASSA, not amended, it still remains as it is. School closure, well covered. And we believe section 37 is comprehensive enough to provide information on how parties should deal with dispute. Norms and standard for LTSM, it's a process that is in there. And the proposal that you remove penalties, we're saying no, penalties will remain because we're giving effect to compulsory school-going age and the fact that children need to be. We can't have children in the traffic lights with parents begging, using their children to do that. We can't have children that are working in farms instead of being in school, and the country just keeps quiet and remove penalties. So the penalties, our suggestion is that select committee, they remain. I'm sure they're getting to the end. Independent micro schools. When I started, I said there's no definition because it's not in the body. And because it's not in the body, it's not for discussions in this Bella bill. But if there are discussions that needs to be commenced with micro schools, then the department will start having those discussions open. Because for us, it's something that we did not explore and we need to explain more. Because our understanding of home education is that it's a family that says our child will be schooled here. But if you're going to apply to home educate your child and you mix this child with other children, then it's no longer home education, it's something else. Then if it's that something else called microschooling, then we need to open discussion and see how it works. So it's something that needs to be looked at. And Minister will say maybe the 7th administration will look into it, but discussions can commence as early as now. Curriculum of ASDEN and those that are followed by micro school said the bill doesn't cover curriculum, so we won't even go there. Micro schools and children that are disabled, we're not dealing with LSINs and we're not dealing with curriculum, so we're not going to deal with it. And micro school can spring up in small school instead of school closure. We close our schools. If micro schools are allowed and are using that, don't mix the two, because those micro schools are independent. The schools we're measuring and closing are schools that, according to SASSA, are not meeting particular requirements. So we may not mix the two. DCAPS, it's a curriculum, and we're dealing with non-curriculum issues here. Legislation, IMS, legit, accountability, and all those things, the statement is not related to the bill. And the person wants us to set a meeting with Umalusi, and it's nothing to do with the bill. There are requirements, the Constitution, to deal with home education, register, offer a curriculum at your own cost, get an independent assessor, you are on the board. Here it says there's a perception that we are affecting that, say it's a perception. What is the relationship between DBE and home education structures? To us, they are stakeholders. That's why when we communicate with them, we invite them, they are stakeholders. And how do we decide who we negotiate? Anyone who comes to us and says, I'm a stakeholder, we don't turn them back, and then we keep their details, and when we have meetings, we call them. Then if you haven't been called, it means you haven't raised your hands and introduced yourself to us, so we may not know where you're operating from. So you are invited to make yourself known. Next time we have a meeting, you will be in our mailing list. Is there a plan to help with CAPS at home? No, the department officials will never come to your home and help you with CAPS. You said you wanted to educate your child at home. If you want information, guidelines, and all those things, yes, we'll be able to provide that. But beyond that, we will be unable to do that. Even those who are learners with special needs that are in micro schools and all that, we will not come and provide you with support there. But we will support those that are in public schools, because you made a choice that you want to run education yourself. I've responded to these LSINs that we're not focusing on them. Home education, read the Constitution. This statement of creating an environment supportive of soft law and all that is not in the bill, so I'm not going to comment about it. The reform of NEPA to accelerate, decelerate, improve quality and all that is not in the bill, it's NEPA, we're dealing with SASSA. Alternative education centers proposed to assist the DBE regulate. No, we don't need a commission. So let's discuss it and find a way on how to deal with it. And this cottage schools, this micro schools, let's have that discussion. Do you want to have a separate act for home education? Let's hear what the discussions are going to say. Irregularities have been experienced during public participation, public hearings in provinces. The DBE did not conduct public hearings. They were managed by the Portfolio Committee on Basic Education. So that's where the complaint needs to be sent to. Chairperson, in closing, we are concerned that people went to your hearings. They've given you a lot of written submissions. And it sounds like you were running a referendum where people were asked to vote yes or no. And when people hear no's, they celebrate. When they hear yes, they celebrate. And because they think it's a referendum. When we provide 54 clauses for people to give us advice so that we can amend accordingly, then people come and say, I don't like clause number 39, and therefore I reject the bill in its entirety. So I don't know, Chairperson, if that qualifies as an objection to the bill, because we can't just throw everything out because you are mad about one thing that is in there. And when people say the majority of the people are rejecting 4 and 5, did you count those who say we accept the bill on its entirety? Because if they say that, it means 4 and 5 is also added. Then how are you calculating that? So people missed an opportunity to inform honorable members how to take a better decision rather than to reject and accept without really giving substance. And that worries us, that if we think the bill will be contested on the basis of numbers and not substance, where we just reject everything. There are organizations that I'm not afraid to mention, Chairperson, your SOU, your FETSAS, that will come in there and say, here is where the problem is, that clause and that clause. If you can change it and make it sound like this, that sounds very progressive, and that's how we move. And that's how we're able to say we're moving away from issues of submissions and the dates and all that, because the information, it's credible and it takes us forward. Unlike the anger that we see. Chairperson, we would like to close it there, and thank you very much for listening to us. But I guess we responded to all the questions and the proposals that you've given us. Thank you very much.
Thank you. Thank you very much, Ndade Ndlebe, for your elaborate, quite detailed responses to each and every question that was asked, including comments and what people actually said. They've got perceptions on certain things. You have made your interventions in terms of explaining how are we going to go forward with this. Honourable members, these are the responses from the department to the public hearings, both written and oral. It is for us now to engage. I know there members will have certain questions of clarity to ask to the department. And I must also say thank you, Ndade Ndlebe, for this is really helpful that people who have raised issues that are not necessarily in the bill, those things are not going to be ignored. But if members and that you said your door is open, the door of the department is open for people who've got suggestions going forward on what should be done with matters that our people think that this needs to be included in the other amendments of the Pella bill. And your explanation that this bill came as a result mostly of judgments, negative judgments from the courts. So we are responding to those judgments by making administrative changes and here and there in the Pella bill. But that if members of us, South Africans and people who have interest in education want to suggest in the 7th Parliament what other amendments need to be done, they're open to approach the department and they'll be invited, depending on what their proposals are, to give input and to actually start the next amendment of the Basic Education Laws Amendment Bill. It's not the last amendment. There could be other amendments going forward. Thank you very much, honorable members. I'm looking at the screen here, and I'm going to take hands as members are raising them, comments and questions. I see the hand of Honorable Christians. Yeah, Honorable Christians, the floor is yours.
Thank you very much, Chairperson. Chairperson, I have a few questions, and I hope that the department will indulge me. Some of them are repetitive, but I would like some more clarity on that, and I'm sure that's why we are here, to gain clarity. So the first question is obviously, and has been debated on quite elaborately through all the discussions, through all the public hearings, etc., and today as well by Mr. Ndlebe. That is about the funding source and the financial implications. Now, during the briefing, we heard that Mr. Ndlebe has said that National Treasury will be making funding available. However, last year, the National Treasury expressed concerns about the financial sustainability of implementing this particular bill. So this indicates a need for a thorough examination and planning, which we have not seen throughout these proceedings. In fact, the National Treasury last year has confirmed that the bill is unfunded legislation. This was done to a letter to the Western Cape Provincial Legislature. And so last year, Parliament's Portfolio Committee on Basic Education also heard that the department would need in essence of around 16 billion rand to implement the bill. So in light of all this, and the fact that we have not really had clarity with regard to the planning around the implementation of the bill, and with regard to exactly how the 16 billion rand will be made available. So I do think that as a select committee, we do deserve more clarity. And I also believe that our stakeholders, our parents, our schools also deserve more clarity around this specifically, taking into account that this is a huge sum of money and that there seems to be a lack of planning around that. My second question is around the procedural integrity and also the public participation. Now, just recently it came to light, and this is for our select committee to take note of, as well as the department, although we know that they have not been involved in the public participation, but it is also for them to take note of the proceedings and the overwhelming public response with regard to the bill. So the integrity and participation during these public proceedings was of huge concern. And I know that the chairperson of the select committee received yesterday a letter from the Northern Cape specifically. And then this morning, we also received a letter from the Free State, where both these provinces had indicated specifically in the committees that the integrity of what has happened during that last committee meeting is a huge concern. Now, my question is, how does the DBE and how will we as a select committee justify the passage of the bill through the portfolio committees despite the overwhelming public opposition? Now, I could name Specifics in the opposition, I could name numbers, but I don't think it's necessary because as a select committee, we have gone through the numbers who have rejected the bill outright, who have rejected part of the bill. Not one of the inputs that we've received thus far as a stakeholder actually agreed to the bill. So the portfolio committee, specifically in the Free State and the Northern Cape, they decided, their decision was to support the bill despite some significant public opposition. And in the Northern Cape, there were about 2,300 submissions, right? And all of those submissions practically opposed the bill. This raises concerns about the integrity then of the legislative process and the extent of the public participation when the portfolio committee yesterday decided that they were going to agree on a negotiating mandate, despite the report from their legal advisors stating that there was a massive opposition with regard to the public participation. Also, then the concerns specifically regarding the denial of the attendees in the Uppington area, the Pitole area in the Northern Cape, where attendees were denied the opportunity to express their views. So these are serious concerns that were raised, and I think that in all fairness and transparency of the public consultation process, we need to review this. And we need to decide as a select committee and DBE whether there wasn't procedural flaws and whether we are not passing a bill simply to pass it and that the public participation wasn't fair. So my question then is, how do we plan to address these procedural flaws and shortcomings that were highlighted in the letters sent to the select committee chairperson? Specifically, what steps are going to be taken where people were denied voting opportunities, where halls were packed full in Uppington specifically, where not one of those people were given an opportunity, so to speak, to raise their concerns. So, given the potential vulnerability of the bill to legal challenges with regard to this specifically, how are we going to mitigate this risk before we proceed? So in the Free State as well, there was limited time for public output. Sometimes they cut off the public hearing after 2.5 hours, even though they hadn't heard everyone. There was also a dominance of the Department of Education, where the Department of Education was allowed to take up most of the speaking time. Up to 4 officials were advocating for the bill. There was an unequal distribution of speaking time, which disadvantaged members of the public. The chairpersons, according to the letter we received, there was also interference from the chairperson, where the chairperson silenced members of the public seeking to give input. And then there was also a lack of impartiality, where the chairperson and other committee members displayed bias. There was also a point where the public voting at the end of meetings also lacked transparency, and this led to confusion as well, causing some of the individuals to leave the meeting before their vote could be considered. And then also across the provinces, I've heard about punctuality issues where the hearings did not start on time due to poor punctuality of the chairperson, and this was further inconvenience to attendees. Then, chairperson, I'm also concerned about the constitutionality and the legal vulnerability of the bill. And again, I asked the question, considering the overwhelming opposition to the Bella Bill, which Mr. Ndlebe also made reference to. And this across provinces, is the DBE and the Select Committee willing to further engage with dialogue so that we can address the concerns raised with regard to the revisions, especially stakeholders, parents that are concerned, so that we can ensure that the effective implementation of the bill is within the bounds of law. So the widespread opposition to the Bella Bill underscores the need for a meaningful engagement with stakeholders. And I do think that we need to go back to stakeholders to address these concerns and not merely brush these concerns away with a meeting to state that we've addressed this and we haven't addressed that. Then also with regard to the financial reports, and I know Mr. Ndlebe also raised this concern quite a number of times. So given the substantial financial and administrative burden that would be imposed on schools by the proposed requirement for quarterly financial reports, particularly without additional funding or staffing support, what specific assistance and resourcing does the Department of Education plan to provide then to schools struggling to comply? And additionally, considering the recommendation from various stakeholders such as FETSAS to focus assistance on schools experiencing difficulties, how does the department intend to ensure that the implementation of this clause is fair and equitable, particularly for schools already submitting annual audited financial statements? So in light of these concerns, this is a question both to DBE and to us as a select committee to consider. In light of these concerns, the potential impact on schools' resources is one concern. So would the department consider tailoring this provision to apply exclusively to schools with specific financial challenges, as suggested by some of the stakeholders, and then by developing regulations outlining the process for rectifying non-compliance, should there be non-compliance, then put in steps for schools to be monitored then on a more regular basis? And lastly, Chairperson, considering all the issues recently and considering that some of the public hearings have not gone as we would have wanted them to go, the Western Cape specifically has asked for an extension, which they have received for 1 week. But in light of the extensive volume of submissions received, and I think that we have dealt with those really in depth at our meeting as well, but specifically in the Western Cape, there has been an extensive volume of submissions received, and this significant turnout of public hearings and the recent development concerning the funding raised by the National Treasury, we need to get further clarification from the Department of Education. Now, in light of this, Chairperson specifically, the Western Cape is then requesting an extension for the negotiating mandate. This will not influence the final mandate, so I would like to propose that we extend the negotiating mandate to a date after the 4th, preferably around the 12th, to allow for ample time for the comprehensive processing of submissions, specifically in the Western Cape, and to address these critical issues so that everyone in the Western Cape can, that can all be documented. The public hearings, the input can all be documented. So that is just a consideration that I would like to bring to the Select Committee. And obviously the date for the final mandate would remain the same. Thank you, Chairperson.
Thanks a lot, Honorable Christians. I just want to check the department. The budget, the 12 billion rands, given what the question, I will follow up to the question that is asked by Honorable Christians. How do we get funding for education, for grade R? Do you get money? Does the Treasury says there is money for education? Do you want use for it, or does the department say we've got these are our needs, this is the amount of money we need? And if it's like that, then isn't there supposed to be a law that guides what the grade R will be doing in terms of the infrastructure, payment of teachers and all that? And that I know that presently grade R is our school our education system started at grade R, no longer grade 1. And that we have students who are at schools now who are being taught by teachers. Who are paying those teachers? Where does that money come from? Are there other questions that members would like to ask? Yeah, in the absence of any question, can we get the answers to some of the raised concerns?
Thank you very much. I'm sure this is where the minister and DG will come in.
And just a little bit, you know, Honorable Christians, I just want to say, in case you know, there were extensions for public hearings. First, it was a week, and then after that, there was a request, and we, after engagement, we agreed on a 2 weeks extension of public hearings. And this we extended to everybody, not only the Western Cape. And that, you know, I guess that if we're all given equal time in this, there should not be province that is given a special treatment as different from other provinces. For me, all the provinces are equal before the committee, that there's no province that will be given special treatment, be given extra months when others are given, you know, when the committees agreed on time frames. And, you know, I'm just saying that those are some of the things that really are worrying me. DG, you may respond to the comments and questions.
Thank you, Honorable Chair and honorable members. We usually led by the minister, and then we come after the minister and deputy minister, Chair, if you allow that.
Yeah, that's the protocol.
Thank you.
No, Chair, if you allow me, I really would, because the technical questions, officials will be able to address some of the questions, unless DM does want to say something. But I just think the department is adequate to answer the questions, especially from the honorable member of the DA. I really don't agree, but I think let the officials explain what the process is with treasury and all other things.
All right,
so
just before Honorable Minister, there's another hand. I think there's a late hand, the hand of Honorable Nkosi. Just sorry about that. I didn't see this number. You might have had problems raising a hand earlier.
Yeah, Chair, I'm sorry. I raised my hand before. Maybe you didn't see my hand. Thank you very much. Greetings to your good self, the minister and the deputy minister and the department officials and my colleagues. Chair, actually, I wanted to say we want to appreciate the responses from the department with regards to the submissions made by different stakeholders. We accepted the responses and we really appreciate them. But Chair, I wanted as well to indicate that I think it's a norm for the Western Cape that all the time they are requesting extensions. In all the bills, if you remember, in all the bills that we are doing, most of the time Western Cape will request the extensions. And in this case, we did give the extensions to all the provinces as we indicated. So I want to put it very clear that this time around, Chairperson, we won't allow the extension. Let us proceed with our scheduled as presented in our last select committee meeting and agreed upon. Thank you very much, Chair.
Thank you, Honorable Nkosi. Is there another hand from the members? Can somebody help me check the platform if I'm leaving anyone out?
No, Chair, there's no other hand.
I have checked and there's no other hand. Will you lower your hand, Honorable Nkosi? Just lower your hand. Thank you very much. Honorable Minister, you may introduce?
No, I said my piece, Chair. I'll ask DM if she wants to say something, then really ask the DG to respond so that we don't take your time. Our presentation was very long and I was worried that we were going to throw us out and say, you're speaking for too long. But thanks for being patient with us and allowing us to go all the length. Thank you very much, Chair.
We wanted as much detail as we can get so that we can be able to process this with information.
Okay, thanks.
Thanks. Thank you very much. DG?
Thank you, Honorable Chair. I hope you can hear me. I'm in the field at Latini. That's why I've joined with 2 devices. And I hope you can hear me, Chair.
I do. We hear you loud and clear.
Thank you, Honorable Chair, Honorable Members, Honorable Deputy Minister, Honorable Minister and colleagues. Chair, thank you once more for giving us this opportunity to come and respond and clarify some of the issues that we've attempted to respond to and clarify. And I must say that in all honesty, they reflect our bona fides in dealing with our lived experience of implementing the South African Schools Act, the Education Amendment, the Education Employment Act, some of the provisions. As I've said, we've effected these changes to deal with those directives from courts and our lived experience. I also want to appreciate the comments and the questions made. I'll attempt to respond to some, in others, colleagues will help me. Well, Honorable Christians asked about funding sources and the budget. And I think Mr. Ndlebe, in our response, has explained this matter. For instance, Chair, I want to combine this with the question that you raised. The provision of educators is funded through equitable share, and posts are provided for in terms of the post-provisioning norm policy. The current post-provisioning norm policy provides for grade R. And the decision that we have taken as a department, in particular by HEDCOM, endorsed by CEM, was that as practitioners become qualified and they meet minimum requirements of being educators, they must then be absorbed in terms of the post basket. The post basket is determined every year as the budget allows. It's a practice that happens every year. So you do have grade R practitioners who are already paid as educators in a number of provinces. There are others who are in the process of meeting the minimum requirements. As soon as they meet those minimum requirements, provinces will deal with this in accordance with their annual post-determination basket, and then include the teachers in the post basket to be paid as they get absorbed. The majority of them are getting what is called an allowance of between 5,000 to 7,000 per month, or a stipend. Let me call it that way. We actually call it a stipend. There are provinces that are paying more than others. We are in the process of bringing a uniform stipend across the board. For those who have not qualified fully as teachers or as practitioners in education, they are paid a stipend. So it's something that has been happening for years. And I'm giving this background to show that whatever amount that we put across necessary for full implementation of this, it's not like we are starting from scratch. The amount that is indicated, it's an ideal situation where we say every learner now would have a fully qualified practitioner paid at the level of an educator. And those processes are in place. Money is made available on an annual basis to absorb educators to teach grade R practitioners. There's never been a problem on this. It's an established practice in the system. There is not even a reason for the committee to worry about it. The curriculum is in place. It's been implemented for years. It's called the National Curriculum Framework for Grade R. The workbooks there are 4 workbooks that we are providing. We've been paying for that for years. The workbooks, 4 of them, 2 per semester that are delivered for grade R learners. We are paying for them already. So the issue of the budget, I'm just demonstrating that the issue of the budget is neither here nor there. It can only be raised, I don't know for what reason. I can give more evidence to show the money that we are paying already is probably even more than what is required. So the notion of saying perhaps funding sources and the budget, we need SORAF, SARA examination and planning. That planning was done many years ago. What would be required would just be to supplement as we get more and more practitioners that qualify, that get absorbed in the system, to afford provinces to absorb more of them, so that over time, every learner has a grade R practitioner who's fully qualified. And that also depends on the extent to which the system is able to churn out the number of grade R practitioners who now meet the minimum requirements like all other educators that are deemed to be practitioners in education who are paid like teachers. The issue of procedural integrity, this one, procedural integrity and public participation, Northern Cape and Free State are being mentioned. How do we justify the process of the National Assembly? Well, it's a difficult question, Chair. I'm sure you'd agree with me. Perhaps the best people to put that question to would be the Portfolio Committee of the National Assembly. But let me just speak from my own observation. Fortunately, and I must apologize, Chair, in terms of the NCOP process, I couldn't, because we are under pressure to wrap up issues of the end of the financial year. I would have loved to attend. But for the process of the National Assembly, I attended, and I can vouch for that process. That process was extremely scientific, even in determining the number of those for substantive rejection, the number of those who had an issue about a particular provision and so on, but elected to reject entirely. It was scientific. It was extensive. It was thorough. It was done in my whole experience. I've never seen the extent to which the NAE has really made a determination as to how to arrive at how the amendments were dealt with. And I'm saying, to sum it all, it was scientific, and it can stand any scientific scrutiny. Maybe political scrutiny and others, I don't know, I wouldn't venture, but a scientific scrutiny, that process can stand. And I have attended close to a quarter to about half of their meetings. I was there, I attended. But I must also say, Chair, to this meeting, it also depends who you talk to. If you talk to somebody who supported the bill wholeheartedly, they would say 8 out of 9 provinces, there was overwhelming support of the bill. That's what they would say. It depends who you're listening to, who's bringing the issue to you, and sometimes which side you want to be also. That's what would determine as to whether you'd say the bill has received overwhelming support. But I'm saying my advice would be the because when this process is challenged in a court of law, it is only facts and figures that are going to count. And that's what the NA has done. And my view is that from my own observation, it will stand even the scrutiny of the highest court, just the way they've gone about it. So I can't speak about the Northern Cape and the Free State. I've spoken about my observation of the NA process because I attended those meetings, a couple of them. I have indeed attended in the Northwest, in Limpopo, in Free State, in Mpumalanga. I think close to half of them, I was there sitting and just listening. I didn't say anything. We were just observing. The issue of the attendees who were not allowed to participate, and I'm sure that also must be put to people who are responsible, but also you can do investigation to test the veracity of what people are saying. Sometimes if people feel that things do not go their way, they try other means. And people see the NCOP process as the last straw in considering these amendments. And they would want to make sure that, given the fact that it's the last straw, they do everything possible to make sure that the bill does not proceed. Plan to address procedural flaws. I've said, given the scientific nature of the process of the NA, and so far, the NCOP process has gone more or less the same as the NA. And my advice would be, in making a determination, it might also be important. I know the chair and the committee will do that. Consider these inputs, whether supporting or against, the substantive nature of them, the relevance of them, and all of those things, which are things that would count when the process is challenged. And I have no doubt in my mind that for now, I don't know if the investigation indicates that there are serious flaws. I think the authorities will know exactly what to do about those flaws. Constitutional vulnerability of the bill, we don't see that unless advisors of the president, before the bill is considered and has gone through all the processes, maybe or any other expert in constitutional law or in dealing with statutes can bring that to our attention. We are not aware at all about the vulnerability of this bill constitutionally. Administrative burden placed on schools in terms of financial reporting. Well, our understanding is that the reporting that you are asking for is done. It's done on a monthly basis. It's done on a quarterly basis. There's no extra human resource asked for now. It's been done even before this bill. We're just aligning it to our reporting process. These things are done. They are not new. Your SGBs will tell you that they receive regular reports, either monthly, quarterly, and so on. We are not asking for an audit, for an extra audit on top of the audit exercise that schools are going through. And of course, if we're asking for that, we'll be expected to put in extra resources. But for now, we're using the information that's been gathered on a monthly basis and quarterly basis by schools. So it doesn't require extra resources, and we don't see it placing an extra burden. We're just affirming the good work that the majority of schools are doing and legitimizing processes that they've established over many years to account. And in school, actually, schools enjoy to account. They enjoy to account. I don't think they would ever disagree that they shouldn't account on things like this. The issue of the Western Cape has been well articulated by honorable members. It's even above my paycheck. I wouldn't venture into that. Honorable Chair, I've responded about issues of the appointment of grade R practitioners and how they are paid. Thank you, Honorable Nkosi, and you, Honorable Chair, for also commending the work that we have done in terms of putting these amendments together and short in covering fully what is required. Thank you, Chair.
Thanks, Ntate Moeli. Is there anyone who wants to make an addition from the department?
No, Chairperson, I think DG has covered us. We could just add one little thing there, which he said, but just to emphasize that when we say the public has opposed this Bella bill, I think it's the responsibility of this committee to look at what were they opposing. Was it based on the bill? Was it substantive? Was it relevant? And what is the nature of this opposition? Thank you very much, Chair.
No, thanks, but my duty as the chair of the committee is to ensure that we process the bill, and that is what we are doing. Are there further comments from the members?
Sure, we are fine.
Sorry,
All
Chair,
right.
Honorable Christiansen's
Honorable
hand
Christian,
up.
I thought maybe it's an old hand. Honorable Christians, do you want to have a second bite?
Chairperson, my questions are not directed to the department. I just want to know, as a select committee, when we will be dealing with the issues as reported by the Free State and the Northern Cape, as per the letters that were received by you with regard to the procedural inconsistencies. And then also, I just want to know about the proposed extending date for the negotiating mandate, preferably around the 12th, if we can just have a discussion around that as well. So just the two matters, when we will be dealing with the two provinces that have indicated that there have been issues, and then also the extension until the 12th, the negotiating mandate. And as I've said, it will not influence the final mandate date. And I think it's a fair proposal. Then, Chairperson, thank you.
Honorable Ndangeni, your hand is up.
Thank you, Chair. Good morning, Chair. Good morning, members. Good morning, the Minister and the Department. Chair, there's something I don't understand, was raised by Honorable Christian. He's talking about the letters, which we don't know about the letters, and that's my thing. And now is asking extension. Extension of what? Because I don't understand. And if we are finished with the department, we can leave. And the department can leave and we can debate what he is asking. And Honorable Nkosi answered that there's no extension. Even myself, I say there's no extension because we give them, everybody, every province was given 2 weeks, not 1 week. Please, Honorable Christian, don't be like that here. Please. Thank you, Chairperson.
Honorable Baha, followed by Honorable Nkosi. I'm giving Baha because he's speaking for the first time.
Thank you, Chairperson. Chair, I think that some of the issues are not for us to be talking about them with the department still with us in this meeting. I think that if we feel that we are done with the department and questions related to what they presented to us, we can then release the department and then we talk about whatever internal stuff that we raise. I'm just making that plea, Chairperson, that we release them and then we can sit and talk about our own issues, so that we don't display our emotions about what other members do in the presence of the department. So I'm saying, Chairperson, if we feel that we are done with the department, probably let's release the department and then deal with issues in-house. Thank you, Chair.
It is an emotional thing, Honorable Baha, and people can raise we also listen to emotions here. It's okay. I want to check if there's Honorable Nkosi, and then I'll give this opportunity to, if there's any comment that will come from the legal division of Parliament on some of the questions that are asked, if there's any comment from them. If you lower your hand in Tadebaga, it will be helpful, and then so I can give this opportunity to Nkosi to address us. Honorable Nkosi.
Chairperson, thank you very much once again. I think if issues are raised before the department, we must respond to those issues there and there. But Chair, I think we all know that after these processes, we will have to have the report where we are going to adopt as this committee. I really don't understand as well the question that is raised by Honorable Christians here, because we are still going to get a chance whereby we are going to adopt our reports and all that. But with regards to the extension, Chair, really, we are not playing games. Let us not play with one mind's another, because we gave the extensions, and we cannot give the Western Cape the extension again. That one, it must be pretty clear that we are not dealing with the extensions all the time. When we meet, we must deal with extensions of the Western Cape. No. Eastern Cape, it's not important to us. All the provinces are important. Thank you very much.
Yeah, I want to check if there's another. If you lower your hand. Is there any comment from the legal division of Parliament from the some of the issues that were raised?
Greetings, Chairperson, Greetings, Chairperson, and the honorable members on the platform, as well as the departmental delegation and everyone that is amongst us today for this meeting. Chairperson, my name is Phumelele Ngema. I'm the parliamentary legal advisor that's allocated to assist in this matter. Chairperson, I think briefly, rather than taking up too much time, as I understand the processes and what I've already received in light of assisting the committee, I believe, Chairperson, with your indulgence and direction as well, it will be wise for me to address the procedural questions when I deal with my own responses, as well as tackling the submissions that have been spoken to, when the committee will be dealing with the process on deliberation on clause by clause and when we have received the negotiating mandates. So, Chairperson, I think in order not to derail the committee process, let me rather reserve my inputs or opinion thereof for that meeting that the committee will indicate. I thank you, Chair.
Thank you very much, Mengem, for that advice. And the time will come where we are going to engage with the report that is given. And just to say, to reiterate what I said earlier, that all provinces are equal in this country. There's no province that is going to be given a special treatment. But you know, we listen when people talk. There was a request from the Western Cape. We gave them, and then we gave everybody an extension of a week. They felt it was not enough. They applied again, and we offered 2 weeks again extension for public participation. And now they want another extension until the end of April. To me it sounds, there is this English word, what is filibustering? I don't know if it will be parliamentary to use that word. That I suspect that there is filibustering on this matter, but I don't think it's parliamentary, or it will be parliamentary for people to be filibustering on matters like this of national importance, matters that deals with the future of this country, because dealing with basic education, you are laying a foundation for the future of South Africa going forward. We have a program as the committee And if there's any suggestion that members would like to make, that we have something, we know what procedures to follow. I think we coming to an end of our meeting, and I'd like to take this opportunity to thank everybody who came to this and their contributions. Saying thank you to the minister. And Minister, if you want to have the last parting shot, the floor is yours, and then we'll close the meeting. We'll release you, and then members of the committee will remain so that we deal with other matters of the committee. Thank you. Minister, DM. Is the minister still in the meeting?
Oh, yes, Chair. Yes, Chair. Yes, Chair.
Oh, thank you. Thank you very much.
No, I'm still in the meeting, Chair. I just
All
was
right,
not
thanks,
listening. I'm still here.
All right. Yeah. No,
Yeah.
thanks. Yeah, you may.
No, Chair, as I said, I'm really grateful that you gave us a chance to come and brief you. I was very worried that we were going too much into details, but if you say that was helpful, indeed, I'm relieved that we didn't really bore you or irritate with a long speech. But as I said when we opened, Chair, this will be and I'm glad that there's determination from yourselves and the team that we have to get this thing behind us. As we open, Chair, we said this thing also is about legal processes. Some of the things you will know very well. For years on admissions, schools will run half empty, and because as the department we don't have powers to force the kids to be admitted, we lose court cases because lawyers will say those powers reside in SGBs. So you have a responsibility to make education accessible. You don't have the power to do it. So we need this thing to pass as soon as possible, Chair. So I'm very grateful that the committee is considering, and possibly by the end of this administrative period, we would have gotten it done and over with. So I really appreciate the opportunity, Chair. So I don't want to say much. We've noted the matters that have been raised by yourself, but also by members of the committee about extensions in the Western Cape. I don't want to get into the Western Cape story because it is province number 9 out of, so it is province number 1 out of 9 provinces. So the less said about it, the better, because I really don't want to get into that space. But thank you very much, Chair, and thank members of the committee for inviting us and really spending more than 2 hours with us. I'm really grateful for that, Chair.
Yeah, thank you. It's written something. No, thank you very much. Let me thank everybody for being part of this meeting and release the department. Members will remain so that we deal with. Nolthando, do you have minutes for this meeting?
Yes, Chair, we've got 1 set of minutes.
1 set of meeting. May you flight them? And just to say to members that this is not the end of the process. We're going to have meetings where we'll discuss it. We'll be going clause to clause, and then from there we'll deal with the committee report. That's where most of the debates will be dealt with by us as members of parliament without the department. That's the minutes of the meeting of the, what is this, the 13th. Those are the minutes. March 8. Yeah, minutes members, any comment? Or if there's no comment on the minutes, is there anyone who move for adoption of the minutes?
Ndungeni moves for the adoption of the minutes, Chair.
In a second, Honorable Chairperson.
All right. Minutes are seconded. Thank you very much, honorable members, and this meeting is adjourned.
Thank you, Chair.
Chairperson.
Thank you, Baya.
Recording stopped.
Can I please ask colleagues to remain in the meeting? The support staff, please.